Hello landlords, it's Ernie, I'm back, and today we're talking all about the essential elements of a great lease. Let's get started. Thanks for all of you who come back to watch our content. Don't forget to comment, to like, and to subscribe if you haven't subscribed. Thanks. So one of the most important questions that we get asked is, how do I start the landlord process if I don't already have a great lease? Well, as many of you know, you can start a landlord-tenant relationship without anything in writing. The state of Texas will allow a landlord and tenant to engage in an oral agreement for the leasing of rental property. However, as you probably would guess, that's not something that I recommend. And so today we're going to talk about the first essential element, the lease itself, and the fact that your lease should be in writing. If you have, for example, acquired property where tenants were previously paying a certain amount of rent, but the lease was lost, or the lease has since expired, my recommendation is in these situations to start afresh. Get a written lease, get everybody who is a tenant to sign a brand new lease with a specific term. Now, you may want your lease to be a month-to-month, and there's no problem with that. But even if you are comfortable with a month-to-month lease, you shouldn't be comfortable with simply an oral lease. Even tenants who are on a month-to-month lease should have the terms of their agreement established in writing in a document that both the landlord and the tenant possess, so that if there is some issue that pops up in the future, you're able to take care of it well because your agreement is clearly stated in writing. So once you've decided that you absolutely need a written lease, where do you find one? Well, naturally, you can seek out an attorney. Those of us who practice landlord-tenant law generally have a lease that we use and that we share with our clients. However, there are lots of good leases in circulation. If you are a member of the Texas Association of Realtors, Texas Association of Realtors lease is an excellent lease. For those of you who are renting multifamily units, the Texas Apartment Association, or the TAA lease, is a common lease that landlords use. Now, whether you have a single family home or a multifamily unit, it really doesn't matter the kind of lease that you use. What matters is really what's in the lease and whether you know how to use the provisions that are there now. What I absolutely do not recommend is that you simply get on Google and type in residential lease and print out the first thing that pops up. The pitfall with this strategy is, while you may find a perfectly usable lease, you may also find that it's perfectly usable in the state of Kentucky or California or New York, and that what you found is not something that is 100% suitable for the state of Texas. Different states have different requirements and different obligations that are established in the written agreement, or that should be present in a written agreement. If you use a lease that is more suited for some other state, you may find yourself in a position where you are being sued because you are not providing to the tenant the rights, duties, and obligations that are otherwise required in a Texas-based lease. That being said, there are good leases that are out there. You don't necessarily have to be a member of the Texas Association of Realtors or the Texas Apartment Association. You actually don't even need an attorney to draft this for you. But where you might need the help of a big organization or legal counsel is when you yourself don't know what a good lease requires. This video will handle a good portion of that, but it certainly isn't going to lay out for you the wording that courts require and that courts prefer when they're reviewing leases in disputes between landlords and tenants. Additionally, what you want is a lease that has borne the test of time. Each of the leases that I've described, including my own, have gone through the litigation process. And because of that, we know the kinds of things that the law requires and the kinds of things that courts require in terms of the written obligations of the parties. And because we know that, we're able to provide a lease that makes the most sense. So now that you have a good lease in front of you, my next piece of advice is read it. It makes no sense for you to have a powerful tool if you don't actually know how to use it. Most landlords that I've come in contact with have never read their lease front to back. And because they've never done that, they don't actually know the rights that are in the lease. Sometimes they don't know their own duties in terms of what's required of them. And this puts you in a dangerous position. If you've read your lease and you don't understand it, well, that's another situation that you shouldn't be in. If you have questions about the lease that you are signing and sharing with tenants, you should get together with somebody in the legal field who can answer your questions adequately. If you yourself are convinced that your lease says something that it doesn't, you should make sure that you fully understand all of the terms that are in that lease. You are better off having a clear understanding of what's in your lease before you sign it than having to figure things out after some problem has occurred. The next part of a good lease is a clear understanding of who the parties are, who is the landlord, and who are the tenants. Are there other people other than the tenants who signed the lease who are going to reside on the property? Should their names be featured in this lease? Absolutely. The parties to the lease are extremely important for a number of reasons. Number one, if you as the landlord sign your lease in your own name personally, you may actually subject yourself to personal liability in the event of some lawsuit. So not everyone who rents residential or commercial property to another party signs as an individual as the landlord. Instead, if, for example, in your case, you have a holding company that is the actual owner of the property in question, you can sign as the name of that holding company, 123 Property LLC, or whatever your situation is. And you can actually sign as the agent of 123 Holding Properties LLC, or whatever your company is called, so that you yourself would not have personal liability. Sometimes management companies are managing property for a landlord and they sign as the landlord of the lease, even though they're not technically owners of the property. If that's your case, make sure that your agreement with your management company explains what happens if a lawsuit is filed, who actually gets sued, who's on the hook to pay for everything. If the property management company is signing the contract as the landlord and your name as owner, whether by holding company or you individually, are nowhere listed on the lease, how could you possibly collect a judgment that's not in your name? Even if you are successful, or your property management company is successful in recovering a judgment against a non-paying tenant or a tenant who damaged your property, if you are not the named party, the plaintiff in that case, how could you possibly collect any of the money? Sure that if you do have a management company operating and managing your property, it's clear in the lease who is the owner, and if you have a management agreement, it's clear within that agreement who receives the benefit of any lawsuit and who's on the hook for any culpability in the event of a lawsuit. The identification of the landlord in your lease is a crucial one. But if you get it wrong, it could cause some big headaches in the future. As well, the tenants who reside on the lease should be clearly understood and explained. You don't want one person to sign the lease when 15 people are going to be residing there. You want every adult who is residing on the premises to be a signatory on the lease. And naturally, there are some exceptions, but unless there's some extenuating circumstance that would prevent an adult from taking some responsibility for living on the premises, you should require that all adults living there sign the lease. This is important because the more people that are on the hook, the more likely it is that you are going to receive your full payment of rent. The fewer people that are on the hook, the less likely it is that you will receive all of the benefits of your lease. Additionally, and this happens too often, sometimes some third party, someone who's not residing on the premises itself, signs the lease for someone else living there. Now, you may not think there's anything terrible about this at first until the problems begin. Sometimes the reason that the people who are living there don't actually sign or fill out the application or subject themselves to a background check is because they are bad tenants, and they have been bad tenants in the past, or they have poor credit, or a poor working history, or a criminal history that would otherwise have turned them away. This is why it is essential that everyone who will reside on the property be identified in the lease, even minors. Their names should be stated so that you know precisely how many people are living there and who those people are. If you are unsure about that, you're not ready to hand over keys yet. Make sure that you get that straight before you have completed the process of leasing to this particular party. So we talked a bit about the application and the process that you go through to get tenants. One essential element of a good lease is the step right before you sign that lease. You want as much information, again, about all of the adults who are residing on the premises, and to make it clear that only those adults who did sign are allowed to occupy the premises. So what kind of information is helpful? Naturally, you'll want a state-issued ID. If you can get a social security number, you certainly want to know the date of birth of each individual who's residing on the property. Because should you ever have to go after any of these people for collection of unpaid rent, you want to be able to associate the named party to the individual who has that name. You know, if you're renting out to Bill Johnson, there are a lot of Bill Johnsons in the city of Houston and many more in the state of Texas, and even more of them throughout the United States. If you want your judgment, should you need to get one, you want your judgment to stick against the individual who actually signed the lease and who is on the hook for these payments. You need to make sure you can identify them so that in the process of attaching the judgment to them, this information gets on their credit history. Make sure you know the particulars of your tenants in terms of, again, their minor children, their pets, their vehicles. All of these things are important in the long run to make sure that only those who are allowed and permitted to be on the premises are actually there. Finally, you're going to want information about the current status of employment for each of the adults who reside on the property. This is helpful in the event that the tenants pick up and go but still owe you money. If you know where they are presently employed, you can actually serve them a civil lawsuit at the place of employment so long as they are still employed there. Additionally, it's extremely important to be able to verify income, and so you need employment information so that you can do that before you sign a lease. One simple practical thing is to keep a hard copy of your lease. Nowadays, a number of people are doing things digitally, and it's very easy to produce a digital copy of a lease and to email it one way or another. Make sure you have a hard copy so that it's clear what was precisely signed in ink, if possible, between all the parties. Even if that's a copy that is simply initialed, you'll want something to clearly identify that this was the final document that was agreed to by all parties. Additionally, you'll want to keep a digital copy. And so if you scan that copy into a digital form of some sort and email that digital file to you, you'll have a copy that's preserved in your email that you can access at any time. But also, it's a good idea to be able to deliver at least a digital copy of your lease to your tenant or your tenants as soon as possible. Don't withhold a copy of the lease for any reason. The tenant is entitled to it. And just as a point of good service, once you have that digital copy, make sure you share it with your tenants. Another essential element of your lease are the rules. Sometimes properties are located in a homeowners association, and the homeowners association will have certain rules and regulations and restrictions. These covenants that you are bound to as the owner pass down to your tenants. But if your tenants don't know about them, it's difficult for them to stick to them. And so it's your duty as a landlord to make sure that your tenants are properly informed of any HOA regulations. Additionally, you may have certain rules for your property. Maybe you have a swimming pool, or you have a particular requirement with regard to your landscaping. Perhaps you have certain equipment that's inside your home that requires specific maintenance or care. It may be as simple as just requiring that your tenants change out the filters for the air conditioning system. If you have specific, very particular ways of dealing with your property, don't just assume that the tenant is going to have those same particular modes of dealing with the property. Write it down. Make sure you have a set of rules and regulations that apply to the maintenance and the care of your home before you sign the lease. Make sure that it is part of the lease as one of the addenda that you require that the tenants abide by. Do you have some particular issue with smoking? Do you have some particular issue with noise pollution? Or perhaps you have some issue specifically with a kind of pet that you will not allow on the premises, or certain activities that you are not, you're going to disallow your tenants to participate in. If that's the case, you should make these things explicit. If they're not already in your lease, they might be featured in your rules and regulations. Generally speaking, landlords are pretty good at identifying the amount of rent. It's very rare that the amount of rent is not prominently featured in a lease. But what might surprise you is just how often the method of rent payment is left ambiguous. Where is the rent supposed to be delivered? I've seen a number of leases that actually leave that section blank. And so enforceability becomes a challenge when your lease itself doesn't even tell the tenant where to make the payment. If you have a specific method of payment that you prefer, your lease should mention it. Do you prefer all payments to be made by money order or a cashier's check, or to be direct deposited into a banking account? You can mention that, and if that is your preference and your requirement, that should be featured in your lease. Should a tenant physically drop off a payment somewhere? Are you going to go to them and collect it? Not something that I recommend, but there are a number of landlords that prefer to simply go to the unit and collect the rent there. Whatever your preference happens to be, it should be listed in your lease. So as far as late fees are concerned, remember that the Texas Property Code sets very specific limits to what you can charge. If you have a multifamily unit, which is 5 or more units, you're capped at 10% of the monthly rent. However, if you're renting a single family home or a unit that's 4 units or fewer, you're capped at 12% of the monthly rent. Now, what does this mean in terms of what you can charge up front? Or that's really up to you. But note that you cannot charge a fee that equals more than 10 or 12% of the monthly rent, depending on the type of unit that you are leasing. Additionally, you cannot assess a late fee until the 4th day of the month. If your rent is due on the 1st, the tenant cannot be charged a late fee so long as the payment is made within the first 3 days. Now, this does not mean that your tenant has up to 3 days to pay the rent. They're still technically in default if they fail to pay the rent on the 1st day of the month, if that's what your lease requires. However, you are limited in your ability to charge for late fees until the 4th day. So again, let's not get this confused. A late payment is still a late payment, and technically still a basis for eviction and termination of the lease, even on the 2nd or 3rd day. Where you are limited is if you accept the late payment, you cannot assess fees until the 4th day or after from the original due date. Speaking of payment, how can you apply payment once you receive it? If a tenant hands over a payment that says, "For rent only, do not apply to anything else," is that controlling when you take that and you cash that particular check? Well, probably not. If your lease has an application of funds clause, you can state unequivocally that you as a landlord can designate how rent payments are applied, particularly if a tenant owes some other fees like late fees, or perhaps didn't pay a full deposit, or perhaps broke a window and should be charged for that repair. If in fact your lease clearly explains that your payment as you receive it can be applied first to non-rent obligations, then you can tell a tenant, even who makes a designation on their check, that the rent will be applied in accordance with the lease. And if there happens to be a rent balance owed, you can notify them of that balance. If they fail to pay that, you can move forward with the eviction process that is required out of the Texas Property Code. So when do you hand over keys? Well, naturally, at the time that you sign the lease, you are obligated to deliver keys, but make sure that when you are signing your lease, you've done your background checks, you've covered your set of rules and requirements either through the HOA or a combination of your own specific rules and requirements for your home, that you have clearly established who the parties are, and that you have collected your first month's rent and your deposit in certified funds. Now, you may not collect any of your other fees this way, but it's important to know that when you start off, that you hand over keys to somebody and sign a lease when at least the deposit and the first month's rent have been paid in a way that you can confirm. A money order is perfectly viable for a certified payment, as well a cashier's check from a bank. If you accept cash payment, which is still allowed, make sure that you hand over a receipt. The Texas Property Code requires that any cash payment that is made be accompanied by a receipt, and that you keep a proper ledger of any payments that you accept in cash. If it just happens that you're accepting the first month's payment and your security deposit in cash, make sure that you're ready with a receipt to give immediately to your tenant. The most important thing is that you've checked off all of the things that are so important, all of these essential elements. I list them here not because it's good to have a handful of them, but it is essential to make sure that you are well protected before you begin this process. Know what you're getting into before you're there, as opposed to people who have gotten into a situation and now are asking someone like me to figure out how to get them out of trouble. If you know these things and hold your tenant to these requirements, you're going to find a much more pleasant landlord experience. As always, I will come to you with new content every week to make sure that you are constantly supplied with the best information to make the best opportunities in your landlording experience. If you have any questions or comments for me, my contact information is here on the bottom of the screen. I encourage you to give us a call, shoot us a text, send me an email. I also respond to the comments that you put on the videos that are presented here. For more information about me and my office and our services, you can check out the video description down below. And until next time, landlords, happy leasing. If you enjoyed this video, we invite you to like and subscribe. Follow our links to even more great content. We're always adding to this collection. If you have a video topic you'd like to see, comment below.